it can be a little convoluted to say the least.
Program director here, and I'll introduce John and hand it right over to you.
Thank you much. So,
Yeah, thanks, Lynn.
so I'm John Harmon. This is Matt Smith. I guess we're going to be presenting on various concerns that you should think of when you are handling a startup, and specifically those concerns as they relate to IP. So, I guess we'll just take it from there. Is there there we go. There we go. So, what does IP do for a startup? There are pretty much as many benefits and advantages for IP as there are different startups. So it really depends on what your actual goals are, and even quite frankly, what stage your startup is at. So this can include everything from marketing yourself to potential investors, as well as strategic alliances when you're trying to raise capital for your company. It can also it can be used to protect the actual investments and the sweat equity that you've put into your company in developing this technology, where you create barriers to competitors coming into the market, where you don't want them to just have some fast follower that comes on, knocks off your product, and starts selling to all of your customers. And something else that a lot of people don't always think about is that patents and other IP can actually can act as an insurance. So all of us have heard of the patent wars between Sony and Apple, where it's assured mutual annihilation. And so if you have some patents that are not only advantageous to yourself or other IP that's advantageous to yourself, it could also be used to prevent someone to come after you when potentially they might have other patents that cover your technology. Perhaps there can be cross-licensing potential. Perhaps there's some other negotiated settlement rather than just going straight to patent litigation. Whereas if you didn't have that protection, you don't have that option. Something else that you could think about is that if you have various types of IP protection, whether it's agreements or patents or trade secrets, is that it can actually help to reduce the potential for people to raid your company, whether that be for defection of your employees, vendors, clients, etc., due to the use of the strategic application of various types of IP. It also enhances the image of your company. So if you can say, oh, we have this brand new patent, it applies to our product, and we're the only ones that can actually manufacture this, and it's a absolutely stellar improvement on everything that's been out there, that really can help enhance your image. And again, that can help with raising capital. It can help with actually finding some clients that find that very attractive as well. And again, it can be used to distinguish products from competition, as well as depending where you are in the lifetime of your company, it can really help you to reach whatever your end goal is, whether that be licensing of technology to other companies, whether that is selling your company to a potential acquirer. They're going to be looking at what IP do you have, what can you actually transfer to us beyond just the actual physical processes, materials, buildings that you might have. So what do you actually have for protecting your IP? There are a number of different tools that you can use, and they will apply in different ways and at different points during the lifetime of your company. And so this will include everything from agreements that you have with various parties detailing how your IP is handled, who owns your IP, other concerns, as well as the more traditional type of IP that everyone thinks of, which includes your trade secrets, your patents, your trademarks, your copyrights. And something else that you should think about, and hopefully it's not going to happen right away, is that part of that toolkit is that you also have litigation is a possible option depending where you are. If you have someone that is ripping off your technology and they are taking your market share, or it's something that is critical to the survival of your company, litigation should be a consideration, even though it's not necessarily the first option that you would choose. And then something separate is that you should also think about using IP audits, where it's really thinking about your entire portfolio strategically, where you are thinking about what do we own, what type of protections do we have, what layers of protection do we have, and how do they work with each other to provide an overall IP strategy that protects our company. And so we're just going to, at this first part, is going to talk about the various types of more common agreements that you might actually see that are useful for protecting IP within a company. And a lot of people tend to just jump to, I just want to talk about patents. But that's only one aspect of an overall IP strategy. So some of the very first things that you might be dealing with when you develop when you start a startup company is that you need to think about how is your IP going to be handled? How do you keep it secret? And that's where confidentiality agreements come into place. And this is also known as non-disclosure agreements. And again, it's handling how is your technology disclosed? How is that technology and the information handled by other people? And what are the consequences if it's mishandled? There are also agreements that you might put into place with your employees or vendors or other entities that you might work with where you're talking about non-competes, where you're really trying to avoid someone actually directly competing with you after you've disclosed all of your information to them, after you've worked with them. There are also concerns, then it'll be present in a number of different agreements where you actually talk about ownership. Who owns the IP? Who owns this particular technology that was developed? And how do you show that it's actually been assigned to the company? And that's where assignment agreements or assignment clauses within agreements will come into play. And then as part of that, you'll also talk about what type of employee and termination agreements you have. So for example, within your employment agreement with your employees, you need to be considering all of these, such as the confidentiality, the non-competes, assignments of the ownership of IP. And then in addition to these more common ones, you will also deal with joint development agreements where you partner with somebody to come up with technology. You'll also have licensing of technology, whether that's licensing technology from a third party into your company or whether that's licensing of your technology out to somebody else to have a revenue stream. And then you also need to think about who's going to bear the liability potentials if you are providing technology to people, providing products to people, and that's where indemnity agreements will come into play. So diving into, quite frankly, one of the most common and probably one of the very first types of agreements that you'll deal with, just talking about confidentiality. So what is the actual purpose of them? The confidentiality agreements are really meant to limit the use and the disclosure of your information, your confidential, secret information that is that is critical to your company. And usually it's going to be for some fixed amount of time, or it's going to be possibly, depending on what type of information it is, it could be confidential for as long as that information remains secret. But who should you think about applying this to? This will include pretty much anyone that will come into contact with your confidential information. This includes people such as your employees, consultants that you work with. You better make sure that when you hire a consultant to develop a technology for you or to tell you what's wrong with your technology, that they're going to keep it secret. They're not going to go out and tell the world or publish on it. I've seen instances where consultants have done research on a particular product for someone, taken that research, and then published it in a journal. And you laugh. It has happened. So you need to make sure that you set up these expectations at the very beginning of the relationships. This is my confidential information. You're not going to tell it to anybody. And this also includes vendors that you might work with, manufacturers that you're contracting with for your product, potential investors and partners, though sometimes that can be a little tricky in that a number of venture capitalists and investment firms may not be willing to actually sign non-disclosure agreements, but considering how you handle information, what information you actually disclose to them will help to limit how much risk you're taking. And then of course, you also have visitors. Let's say you have visitors walking through your lab. You might have something secret or that is just very apparent from whatever machine you have sitting on the desktop, or that they can just look at and say, oh, that's interesting. And if you don't have some sort of agreement that people are signing when they're coming into your facility, that can create problems in terms of disclosures. So something else to really make sure that you pay attention to is that when you're disclosing information to people, even if it's under confidentiality, sometimes they improve on it. So you provide that information to the consultant that you hired for your product, who's going to own the improvements on that confidential information. So really thinking about specifying who owns what based on the new technology that's developed out of your disclosures to people, it at least needs to be considered and, quite frankly, written down. Because if you don't have an agreement beforehand, well, quite frankly, that's where you're now paying someone additional money for developments they made using what you told them. And this last point here, it sounds very silly to say, but really developing a written policy for your confidentiality policy, it's critical. A lot of people just will do this ad hoc, where they say, well, this is confidential, this is the way we'll handle it, but it's not systematic. And when things aren't systematic, mistakes happen. And then actually marking materials as confidential, where you say this is confidential, this is not, and then handling it appropriately and making sure that people that you disclose it to handle it appropriately. That can be very critical in maintaining your confidential information actually secret. And then the last point here is that actually keeping the information on a need-to-know basis. You don't just distribute all your confidential information to everyone in the company. You don't provide everything to the consultant. You provide them what they need to know when they need to know it. Because again, it's the fewer people that know a secret, the easier it is to keep a secret. Okay, so the next type of agreement that many people will be dealing with, and this is, many of us have probably seen this in employment agreements that we've signed ourselves, are non-competes. So what's the reasoning behind non-competes? Usually people will learn a lot of confidential information about a company. They'll learn all of these strategic information, whether it's customers, whether it's how you're doing a particular process. It's just that they basically learned your entire business by working with you. And so for particular key employees, you may want to actually limit them from being able to compete directly against your company, where they're going to take your market share away from you. And so it's preventing really the key employees from opening shop across the street. And so it also, when companies will come along and they will see that, oh, the company X has a non-compete agreement in all of their employment contracts, hiring your employees away from you, poaching your employees can become a lot less attractive to them, because they realize that when they try to hire them, well, they may not be able to work with them for 6 months or a year. And it also can prevent runs on your customers, because if you have someone that is hired away, they know who your customers are. They know what they want. They know what their needs are. They can tailor their products to undercut you. And so again, putting these agreements in place that help to prevent people from intentionally competing against you after they've worked with you can be very critical for your companies. But there are a lot of limitations to this. And really the sort of sniff test that you might use is that it has to be reasonable in duration, territory, and scope. You can't just say, you've worked with me for 6 months, you can't work anywhere in the world for the rest of your life in anything that competes with me. It's just not reasonable. Yes?
Could you give us some specific examples of what's legit in Massachusetts and California?
Legit in Massachusetts and California, I'll probably refer you more to an employment lawyer. But it's, if you were to say more along the lines of, you can't work in the specific field that this company is actually operating in, not just a huge general field, and it's maybe limited to the actual markets you're operating in. And it's, I don't know the exact term that they say is reasonable. I haven't looked at this particular part of the law, but it's typical terms that I've seen are usually on the order of about a year. That is much more reasonable than, say, the other prototype where I said you can't work anywhere in the world in any of these fields that compete with me in any imaginable way. That one won't work. And again, if you want some more specifics, I can always refer you to some employment lawyers I know that would be much more familiar with this. So again, who would you actually apply this to? Key employees in the company. You'd probably think about anyone at the corporate level, at the executive level, are probably people that you might want to include in non-competes. Someone in the mailroom, probably not as much. So the officers of the company, critical suppliers and distributors, saying that you will not work with our competitor in this particular space because we've told you all of our secret way of making our particular material, this process to actually create something that will actually function, as well as even consultants that you work with. So the next agreement that you really need to consider when you're setting up an overall IP strategy for your company is who owns your IP. And this is, again, it's related to the assignments where you're formally transferring ownership from people to the company. And so with IP, who generally owns IP outside of some actual assignment, outside of some formal transfer of ownership, is that IP is generally owned by whoever develops it. That could be the inventors, it could be the authors, it could be the photographer, it could be the web developer that creates your actual website for your company. And if you don't have a written agreement with those people, guess who owns it? You don't own it. That photographer owns all of the videos that they just made for you about how cool your system is, and you have to get permission from them to distribute that. And so making sure that you set up those agreements ahead of time, that who's going to actually own it, that's critical. And so ensuring that the IP is actually assigned to the company. And who do you really need to think about when you're working with that you need to actually actively create these assignments? This includes the actual founders of the companies. And I'll talk about some issues specific to them in a second. The employees of the company. So when you have that employment agreement with them, actually formally saying in the contract that everything that you develop as part of your employment for this company is owned by the company can be critical. And I have seen instances where consultants and employees didn't have the specific terms in it. It said that they will assign to the company as opposed to they do assign to the company, and it sounds like a very minor difference, but getting that right is the difference between litigation and paying very large sums to people that you previously thought had actually developed this technology for you. And it also applies to artists, photographers, and even your interns that you might hire for the summer. Yes?
Just a similar sense, you don't have something in writing specifically addressing that. If they create it, you know I'm paying them.
There are some minor caveats to that, but that's the general rule. If you don't have a written rule or a written contract that says what you develop, I own it, the inventors own it, the authors own it, the photographer owns it, and that can create, actually just look at Facebook, right? There's that entire fight between the guy that hired him to develop some sort of social network, and then there was no actual written contract that said that he actually did assign it, at least that they were able to prove out in court, shall we say. And I mean, that was worth billions of dollars. So it sounds silly, but it can have very large ramifications for a company. So the last,
So even you pay for their time and services, you still own, and that it was written.
correct. So when you're setting up the contract with someone to create your prototype, as part of that part of that consulting or design contract, make sure that anything developed by them for your design, you own it, they don't. And I've seen multiple instances where people have contracted to have something developed for them, and when they then turn around and say, oh, here's this wonderful prototype, I want to patent it, here's an assignment for you to sign for me, they say, no, you need to pay me more money now. And that's what you want to avoid. So thinking of this beforehand when you're setting up these relationships with various people outside the company, it can be critical for you. And even within the company, even at the very genesis of the company, it can be very critical to make sure that you set up who's going to own what. And specifically with the founders, usually it might be two guys out their dorm room, maybe two people that have worked together in the past. They have created some technology. Well, let's say everything works out great, they have a company, they eventually sign things to the company maybe a few years later, and they all make lots of money and they're happy, it's great. The problem is when it doesn't happen like that. Let's say that instead they find out that they hate each other and they decide to split ways. Well, again, who owns IP and the assumption that there's nothing else happens? Both of them own equal shares in the IP. So if you both own shares in that patent, in that copyright or whatever it is, they can go out and they can sell those rights to somebody else, and they don't have to ask your permission. And so it can create where you might have your competitor now has rights to the same technology that you thought you would only have. And so setting up at the very beginning of the startup, actually having the co-founders assign the IP to the company, it can help to avoid that split ownership issue if the business relationship falls apart.
Would you see something in particular if, let's say the company goes south?
Mm-hmm.
So I've created it, I've assigned the patents to the company.
Mm-hmm.
It goes south. Now the company owns it.
Yes.
I don't have anything left. You see like a clawback or something like that, or?
I mean, contracts can be written in any various number of ways. I mean, if you're setting up as part of your corporate agreement that the company goes belly up, then everything goes back in equal shares to everybody else. It's whatever you and your corporate attorney have sort of devised as part of the founding articles for your company. But it's again, it's whatever your imagination can imagine. But at least you've thought of it, and that's what you need to make sure you do, is that you think of it strategically and thoughtfully. So what about licensing of IP? So this is where maybe you have been working in a university lab, you've developed a lot of technology, you now want to go out and do a startup. Well, you need to think about all that prior work you did. You probably need to license something from them because they've probably filed patents on it. You've probably been involved in helping to write those patents with outside counsel. And so at least thinking about what technologies that we think of optioning or licensing and getting those arrangements set in place is something to think of. But as part of that, a lot of people will tend to, especially coming out of grad school, where they have access to labs, for example, It's extremely convenient to just say, I can just take all of this stuff. I can work in the lab that I used to work in grad school. I have this wonderful relationship. We'll all publish on it together. The problem, if you're using the resources of your prior employee or your current employee, if you're using those resources of the university, guess what? All of this new work that you thought was probably owned only by yourself, it may be completely owned by the university. It may be partly owned by the university, and all of a sudden you may find yourself where you have to license what you thought was completely yours. And so at least being aware of things such as employment agreements that you have with your current or prior employees, saying like you have a right of assignment to them of things that you develop, thinking of even non-competes that you might have with your current company. Let's say you work with a company that creates actuators, and you've come up with this new actuator, but you have a non-compete that says that you can't do anything in actuators for the next year. Well, guess what? After you stop working with them, you can't go out and file on patents or start a new company going after that without infringing or breaching your original non-compete agreement and your employment agreement with your prior employee or employer. And again, since you're trying to sort of make this clean break between what is or was your prior employment and what was owned by your prior employer, don't use the company resources when you're trying to come up with something that's wholly owned by yourself. Really make a clean break. Be thoughtful about what you're doing, and separate your current work from your past work. So now turning away from agreements, we can talk more about what people typically think of when they think of IP. And these are sort of the four general areas where you, you have trademarks, you have patents, you have copyrights, and you have what many people oftentimes don't even consider, and they certainly oftentimes get it wrong when they do consider it, trade secrets. And so, and this is just getting at the idea that there is no one thing that is your IP. It's not just the prototype you develop. It's not just the new material or the new process that you've come up with. It needs to be an entire consideration of all of these different areas and how do you implement it to come up with an overall strategy to protect the IP of your company. And so just jumping into what a trademark is. So a trademark is a word, name, symbol, or any number of other identifiers that identify or distinguish your goods and services from another seller, manufacturer, or other entity. And this can literally, it includes everything from like Just Do It to the MGM Lion to the even colors, like John Deere tractors. They're all a very specific shade of green. You see that green, you know it's John Deere. You know that it's the UPS truck going down the street. And even things as esoteric as tennis balls that have the smell of grass, believe it or not. There is a trademark on that. So what should you consider when you're dealing with trademarks? Many companies that I've come across, they oftentimes will just choose their company name, they'll choose their product names, and they don't give any consideration to whether or not somebody else is using it. And one of my friends from grad school did exactly this. And 4 times in a row, he picked a different name, and 4 times in a row, he then got a cease and desist letter saying that you have to change your name. And so he could have avoided this by simply doing a rather quick and not too expensive clearance search, where it's basically just for a relatively small fee, you find out if somebody else has some mark that's similar to yours in the same field. And why is this important? One of the worst things you can do is, let's say that you've been operating for 2, 3, 4 years, nobody said anything, but now you've released products, you're getting some nice press, people recognize your name, and all of a sudden you have to change your name. All of that goodwill, all of that recognition, everything else, it's out the window. And so just doing this at the very get-go, it helps to avoid that type of situation. It helps to avoid that loss of your investment in the reputation of your company. And so how do you actually obtain trademark rights? Yes?
Have you seen cases where you don't have to license a trademark, or what's if you've invested a fair amount, what can be an outcome?
I mean, again, it's whatever you can imagine as a possible outcome. It's going to be very, very fact specific. You can license trademarks, you are correct. It is going to be, again, it's going to depend on who are the players involved. If it turns out that they're developing a product that is a direct competitor to you, good luck. If it's somebody that's in a completely different field, and let's say that Just Do It, Nike only wants to use that for their sports apparel and wearing things and for some reason you want to use it for, I don't know, fishing lures. Maybe you can somehow license that from them because they don't care about fishing lures. But it's really going to depend on the parties involved. But again, the easiest way to do it, avoid the situation in the first place, just do a quick clearance search, and if things work out, you have your choice and you move on your way. So then the question is, now that you've identified whatever mark you wish to use, how do you actually get it? So there are a couple different ways. One is that here in the US, you can actually just acquire rights to a trademark by just using it. And this is through common law, and it's going to be limited in terms of the geographic area and the actual products and services that you're selling. So if I'm operating a small plumber shop here in New England, and I have it's Joe's Plumbing. Maybe nobody else in New England can use the name Joe's Plumbing, but if there's somebody in Texas or California or somewhere else, they could be Joe's Plumbing. There's nothing I can do about that.
And they can't run you?
No, and assuming they don't have some federally registered trademark, which has...
So even if they do business only in Texas and they've registered federally?
Well, there are some things, but the federal registration gives you a much broader protection across the entire country versus much more geographically centered. And this is where also you might be interested in foreign rights, though. And if you are interested in foreign rights, other than the UK, there is no other country in the world that will allow you to get trademark rights simply by using them. And so that instead requires you to register. And this could be anything where it's an actual registration where you say, I am using this mark, and these are the services or the goods that I'm actually selling or providing right now, so please provide it to me. It could also be what we call an intend to use mark, where it says we are intending to sell these products in the future, and we'd like to just at least reserve our name, reserve our mark, or reserve whatever you're using. And this is available both in the US and in foreign jurisdictions, and you can actually file what we call an international application, which for relatively not too much money allows you to easily go into the various different countries. So what is a copyright?
Excuse me, quick question. What is the approximate cost for filing in the US? And what is the cost typically for doing what would be a reasonable trademark?
So for the US, I think that typically applications for trademarks are in the order of a few thousand. International, I would have to go talk to some of my colleagues, but it's the same approximate order, I think, but it's much cheaper than patents. So usually, and you're not dealing with a million different marks at the beginning of a company either. It's usually, here's the name of the company, we'll file it once, a few $1,000s, and typically that will be all for a while. And then once you start filing internationally, it can become a little bit more expensive because you're having to deal with Europe, you're having to deal with China, you're having to deal with other ones all at the same time. But it's cheaper and typically faster than the patenting process. So a copyright is any original work or of authorship that has been fixed in a tangible medium. And this is extremely broad. It literally means pretty much anything that humans do almost. It includes software that you write, databases you create, the manuals for your products, actual physical models or sculptures, artwork, photography, videos, your website that you might have for your company, the advertising and materials, your catalogs. Literally, it's pretty much anything that you have that you develop for your company. It's potentially copyrightable material, and you should think about whether or not you should use copyright to enforce something versus patents versus trade secrets. And so what does having a copyright actually entitle you to? So having a copyright entitles you to reproduce or copy the work. You can distribute it, i.e. sell it, give it away, poster it across all of Boston, whatever you wish. It also allows you to create what we call derivative works, which are usually modifications of the original product you made. So let's say instead of a three-dimensional sculpture, maybe you've taken a photograph of it. Or maybe you've taken a play and you've turned it into perhaps a synopsis, things like that. And it also provides you with the rights to display or perform that work publicly. And so when it comes to enforcement of your rights for your copyrights, telling people not to use them or to go after people if they have infringed on your copyrights, it doesn't actually require notice. You don't have to go around announcing to the world, this is my copyrighted material. However, it's not a bad idea because it indicates that the work actually is protected by copyright, and you can prove that they were bad actors, that they did have notice. There's a reason on every single video that you play on your DVD, it says this is a copyrighted material. That's because they're providing notice to you. This is copyrighted. You can't reproduce it. You can't display it publicly, or you're going to be, every single time, it's like, I forget exactly what the statutory damages are, but they're large. It's on the order of like $100,000 or so. For example, there's a little copyright down here at the bottom of the slides. So again, just like other IP, generally, unless there is some other agreement in place, unless there is some other caveat that's happening, copyrighted work is going to be owned by the author of that work. So it's going to be owned by the photographer. It's going to be owned by the coder or the software engineer that you hired. And the only real caveat to that is that if something is a work for hire, then it's going to be owned by the company. But it's much more limited than a lot of people tend to think. So it's going to be, if something is created by an employee of the company in the ordinary course of their employment, that would be a work for hire, and that would be owned by the company. So let's say that you have a software engineer, and they have written an entire software suite for you, but they did that as part of their employment, and that was sort of the envisioned duties for them. That would be owned by the company. But let's say instead you had an outside consultant that wrote the code for you, or a photographer that took those pictures or designed your website, and they did that for you, but you didn't have an agreement with them. Those people are not employees, and therefore it's not going to be subject to the work for hire exception. So independent contractors, consultants, designers, photographers, all of those, you need to make sure that you get an assignment in place. So when you are setting up that contract with them to develop your website, when you're setting up that contract for them to film that entire video session of how your product works and that you're going to release to the world to demo your product, make sure that you have an assignment of that product to the company. So oftentimes, I like to say that trade secrets are one of the most ignored aspects of IP. And it's truly unfortunate because sometimes trade secrets are the most valuable things that companies own. For example, Coke. It is literally the thing that I tell to everybody. It is the prototype of how you keep a trade secret. They've had this thing for a trade secret for over 100 years. And and they do that by keeping the recipe secret. And it is, as long as it remains secret, they have this infinite protection. It will just keep going on. Versus patents, it's limited in term, limited in how you enforce it. And it can apply to any number of different aspects of IP that are valuable for the company. It's any confidential business information that provides a competitive advantage to your company. This can be as diverse as recipes, customer lists, vendor lists, marketing data, manufacturing processes, even the prototypes that you're developing. But there are some steps that you need to take to actually do it. So, and specifically, they need to be reasonable steps to keep it secret. But what's reasonable? It's a very squishy term. One of the very first things, and oftentimes it's the one that most companies don't actually do, they don't actually identify their trade secrets. They just basically say, we're going to keep things trade secret. That's not enough. You need to actually go in and you need to actually identify, it's this aspect that we're going to keep as a trade secret versus this aspect over here, it's not. And then once you've actually identified your trade secrets, you need to actually take steps to keep them secret. You need to have confidentiality agreements. You need to limit access to them. You need to actually mark them as confidential. Yes?
So I work in sales,
Mm-hmm.
and I'm talking to people,
Mm-hmm.
work on all around different contracts. So I'm putting information into line for hire.
Mm-hmm.
I put information into their database, but do they own the fact that Joe Smith works for whomever, and I can never use that? Because it's, Jamie Dimon works at J.P. Morgan.
I don't, well, that gets to the next points actually here. It needs to actually be private, confidential, secret information. So the fact that Joe works for J.P. Morgan everybody, you can look that up. That's not secret. So if it's not secret, you can't have it as a trade secret. And so you,
Someone's on like now LinkedIn. Everybody's on LinkedIn,
Mhm.
right?
Yeah.
So there's no way anybody. I'm working for a company. I find somebody, I research them on LinkedIn.
Yeah.
And and I go on to the next thing, and I happen to come across this guy, or remember he's got a unique name or something like that. I remember this guy's only. Who owns it? I mean,
Well, again, I don't think any of that's secret, so it needs to actually be something that's truly secret. So let's say that you have a customer list, nobody knows who your customers are, and you want to keep them secret because you don't want your competitors to go poach them from you. That, I would say, is secret. And that's something that you want to keep as a trade secret potentially if it's that valuable to the company. But again, it's going to be very fact specific as to what information you're dealing with. But sort of regardless of what you consider to be your trade secrets, you need to actually set up a policy to handle your trade secrets. You need to educate your employees, this is how we handle our trade secrets, regardless of what they are. And then one of the biggest things, again, that I see that people don't actually do, they don't follow their policies then. They don't keep people out of the restricted labs. They don't put things back away where they have restricted access to them. They don't mark things as confidential, or they don't follow the confidentiality protocols that they have in place. So, and that gets to the fact that you can lose your trade secrets if you don't follow these protocols, if you have a public disclosure of them, if you have something that can be reversed engineered when you disclose it to the world. It's not a trade secret anymore.
So
Yes?
can you, how do you put it, trade secret versus copyright? If you want to keep that information or video, photograph, or the database,
Mm-hmm.
give to your employee, what will you say? Is it a trade secret or is it confidential? Oh no, is it a confidential or is it copyright? How will you say?
Well, again, you could have both. You could have something that's confidential and you have copyright in it. They're just two aspects to consider when you're thinking of an overall strategy for how do you protect the IP of the company. And so just because I want to be a little aware of time, I want to leave a little time for my co-presenter here. I want to make sure we start moving along here, sorry. So what is a patent? It's a legal right to prevent others from making, using, selling, offering for sale, or importing products or services into the US. And one of the things that a lot of people misconceive here is that a patent does not give you any positive right. It doesn't give you the right to make, use, or sell anything. It just provides you with the right to prevent others from doing so. And so there are three primary types of patents here in the US that we deal with. And the first two are the ones that actually the first one is what you also see more typically outside the US as well. This includes what most people think of when they think of patents, which are utility patents. Typically these have a term of about 20 years from filing, from when you first provide your application to the patent office, and they'll cover everything from, say for example, medical tools and implants to machines, systems, consumer products, software, as well as compositions of matter. And this is again what most people think of when they think of patents, but something.
Your clock starts when you file your application.
Yes.
Not when you're granted the patent.
Correct. That's a little different from what design patents, which can be very valuable. Just again, think of the design patents that were enforced against Samsung by Apple. Huge damages there, and that was based on their design patents of the look and the feel of the iPhone. And again, it's really going after protecting the ornamental appearance of your whatever article or device that you're selling to people. And unlike utility patents, it's not from the date of filing, it's 15 years from the date of issue. So it's a little different there. And something else that a lot of people know about and sometimes will misuse are what we call provisional patent applications. This is where you file a provisional and you're then given a 1-year term in which to file your regular utility application afterwards. And it's really just providing that mark in the sand to say that this is the information, this is the technology that we owned as of this date. So what are the standards for actually getting a patent? So patents must be non-obvious. So the claimed invention cannot have been obvious to someone skilled in the art when you actually invented it, when you filed your application. But what's the test for that? It's one thing to say something is non-obvious, it's another to figure out what that means. So the test is that you need to figure out what are the differences between what you're trying to claim in the patent versus what has been done previously. And so based on that, you then say, well, a person of ordinary skill of art, looking at these prior references, looking at what's been done in the past, this would not have been obvious to them to make this change, to develop this new technology that we did. But oftentimes inventors, what they think is obvious is not obvious. And there's any number of times where I've been working with professors who, these people are not people of ordinary skill, they're people of extraordinary skill. So what's obvious to them, because they've been in this technology area for decades, they think, well, it's just completely obvious to take these two concepts, put them together, and of course it will work. But to your average person, to what is the legal standard for obvious, it's not actually true. And so taking a step back and actually considering what is something that you could protect, and talking with a patent counsel can be very helpful here. And for example, there was a person I was talking to here in this room at another Enterprise Forum event where he was telling me, oh, our company, all we do is we take existing electrical grid equipment and we install it at high altitude. There's nothing new that we're doing here. And as we continued to talk, he said, well, there are a lot of problems when you try to install this equipment up at altitude, so we have to make all these changes to it. And as we kept talking further and further, he started saying, you know what? Maybe it's not so obvious. Maybe we should think about patenting these concepts. And so, yes? Yes. So you can cover methods, compositions, systems, processes. You can even cover software in certain ways, but that can go down a little bit of a rabbit hole. And maybe we should hold some of the questions more towards the end, because again, I don't want to keep things too late, and I want to give Matt some time as well, because he has, coming from the startup that he has successfully been transitioning through a lot of these stages, I think his input would be very valuable to you. So what are some of the considerations that you need to think of when you're dealing with patents? One is that patents are what we call jurisdictional. So if you have a US patent, you only have protection in the US. So if you want to get protection outside the US, you need to file in those other locations. And this can be done, excuse me, this can be done through what we call a PCT or an international application, as well as filing direct international applications in those countries. So you could either file a PCT, which is, in essence, it's a placeholder for later on down the road, or you can file directly in Europe, directly in China, directly in Japan, wherever you need to. So something else you need to be aware of is that patents are time and activity sensitive. So there are a number of different ways that you can lose your right to patent something. So let's say that a third party activity or disclosure, they know what you're doing, or they're doing something similar in the same area. And even though you've already developed your invention, your technology, if somebody else comes out and they patent it first, if they disclose it in a paper, in a journal article, and they do it before you get your patent on file, you don't get a patent. It doesn't matter. It's an absolute bar to you. Now, there are some things where if you have public disclosures and your own disclosures, there's a little bit of leeway there. So, and these disclosures can cover a lot of things that people don't think of as disclosures. This can include the regular publications, the journal articles everyone thinks of, but it also includes disclosures to vendors, sales of your product, even secret sales, where nobody outside of the two companies know of it. That can be a disclosure that could actually prevent you from getting a patent. Here in the US, though, you're given about a 1-year grace period in which that you can still get a patent even if you have those disclosures. However, globally, most countries, it's an absolute bar. It varies from country to country, but if you're interested in international rights, we always like to tell people file early, file often, and definitely file before you disclose. And so one other thing I want to really touch on here is that a lot of people misuse provisional applications. A lot of people think that if I take that journal article that I'm about to publish and I put a cover sheet on it and I send it to the patent office, that's good enough. Quite frankly, it's not good enough. There's a company that I work for right now where their prior counsel did pretty much just that for them. And we're literally fighting over the definition of what resistive heating of a material means, where you pass a current through it to heat it up. And instead, I'm trying to argue against an examiner that is saying that you have a resistive heater, and that's resistively heating the substrate, and no one would actually think that. And if they had spent the time and just a little bit more money up front to actually write a good application, we would not be having those fights right now. So what are some of the considerations you should think of when actually coming up with a patent strategy? One is that you need to be aware that patenting inventions, it's expensive. And so thinking about how to do this strategically, how to do it economically can be very important. So one thing that you could think about using are what we call patentability searches, where you will look at what has been done in the past, And then based on what you identify, you can then define, well, this is what's been done. What can we actually patent here? What is the scope of coverage we could get? And then based on that information, you can then make a strategic decision, well, we will patent this or we will not. And at least then if it turns out that, for example, I've seen this occur, you do that search and you find something that literally looks like someone came into your design lab and it looks like they copied your design, well, you don't have to spend the money for that patent. But at least you know before you do so, as opposed to going 3-4 years down the road, finding that patent then after you've already spent this money. And so then you need to think about how do you actually prioritize the inventions that you want to patent. Thinking about whether or not the invention that you've come up with will actually be relevant for your envisioned product. Thinking about whether or not the inventions that you would want to cover in a patent, whether or not a competitor can easily design around them to circumvent your coverage. Thinking about whether or not you can actually figure out if someone is infringing you. Let's say it's a manufacturing process that you cannot tell that your competitor is using, or that your competitor cannot tell you're using. Maybe that's better for keeping as a trade secret rather than a patent. And then also, this last one right here is whether or not choosing to go the trade secret route is a better idea. So when you start thinking about foreign filing, though, that's where a lot of the prices associated with patents can just explode. Just because you're not only dealing with patent applications in the US, you're dealing with them in Europe, you're dealing with them in Japan, China, wherever you're interested in. And they're all going to be happening at the same time. So all of those costs are going to be hitting at the same time. So thinking about where your competitors are located, thinking about where your markets that you're going to actually sell into. If your market is only US and Europe, you know what, maybe you just file in the US and Europe. If your market is Japan, maybe you go after coverage in Japan. And so, and also thinking about whether or not you can enforce your rights there. So let's say that going into India, even though it might be a big market for something that you have, realizing that it's very hard to enforce there, maybe that influences your decision whether or not to go into India.
Can you
Yes?
give us generally for a well-known firm in Boston, what a provisional patent will end up costing for filing and what a regular patent will be, utility patent? And again, ballpark.
I mean, it's really going to depend on the technology and the extent of the disclosure. If it's a very simple, say, mechanical commercial product, you're probably talking somewhere between, let's just say ballpark, $10,000, maybe a hair less, maybe a hair more, depending on the complexity. Let's say that you're talking about the newest. Well, that's the thing with provisionals. I always suggest to people it's always best to file it to write it as if it was a full utility quality application, as if you were to turn around the next day and file it as a regular application. That gives you the most protection because again, if it's not in that provisional application, you don't have protection to it. And so that's why oftentimes people will use provisional applications as sort of a false security blanket. It really doesn't do anything to you if you don't put the time and the effort into it that it deserves. Now, if you're talking, let's say, instead of just a very simple product, you're talking about, let's say, the latest blockbuster drug that some pharmaceutical companies going after, those applications are like 200 or 300 pages long, and I don't even want to know how much they cost, quite frankly. But
But it's something for a simple mechanical might be 10, a sensor, electronic sensor. Can you budget 20?
I would say that I would say for your typical, let's say like a more limited disclosure, again, lower end, maybe below 10 for very, very simple mechanical things. For maybe a more typical range, maybe if it's a little bit more complex, 9 to 12. If it's getting to be a little bit more complex, you're getting outside of like the very simple mechanical systems, maybe more like 12 to 15. And if it's multiple disclosures within something, you just sort of, it's going to be very fact specific, and that's where having a discussion with whoever you have as your patent counsel would be very prudent to find out what should you expect to cost, because you should know what you're getting into, and your patent counsel should tell you roughly expected costs before you contract with them. So sort of running into the home stretch here, and I'll try to hurry it up, sorry. Oftentimes I will have this conversation with people at almost every gathering I go to. They say, well, why should I patent my software? It doesn't work, and I can just use copyrights to cover it anyways. Copyright will only cover the very specific code that you write. So unless you have your competitor literally decompiling your code, copying it word for word to their product, and then using it, you can't use your copyright to cover them. Instead, you really need to think about what functionality does your product have, and how do you actually protect that using patents or trade secrets or some other concept. So quite frankly, software will have a very limited use in protecting your software for your IP needs. And this also brings us to the use of open source code. Startup companies love open source code because it is free usually. And it's wonderful because it's free. It's collaborative, they have wonderful functionality, you can collaborate with people all over the globe, and you can use things that have already been developed for no development cost. The issue with this is that oftentimes those open source codes come with contracts that you have to agree to when you download it, use it, install it. And oftentimes those things will say that if you cannot use this in a commercial product, or that if you do develop a new code with this, you have to make it free for anyone to use. So that code that you just spent the last 2 years developing and maybe $100,000, just because you include this one little module that does a little bit of image analysis for you, all of a sudden you have to disclose it to everyone in the world. So being aware of those contract terms, being aware of the risks and the benefits of using open source code, just be aware of it, use it strategically. So now thinking about sort of overall IP, just make sure that you really plan for the future, because failing to create and implement a well-planned IP strategy can lead to a number of dire consequences. It could lead to an inability to actually protect your IP. It could lead to other entities, such as your current or prior employee owning your IP and having to license it for them. It can also lead to unnecessary expenses and delays in getting coverage. So what should you do, at least in theory? So it's important to review your IP early and regularly. So this includes both scientific developments, technical developments, as well as business developments, thinking about an overall strategy that covers trade secrets, copyrights, patents, etc. And make sure that you develop that strategy early on. Don't wait until your company's 3, 4, or 5 years down the road. It may be too late to actually go back and fix a lot of those problems. It's a lot easier to do it right at the beginning than it is to go back and fix it. Perhaps think about using patentability studies strategically to avoid unnecessary costs when you may not get any significant coverage from a particular technology. Also use provisional patent applications strategically, because you can help to delay the timeline that you might have to do for a lot of the costs associated with patents, other than that upfront cost of doing it right. And also make sure that you file soon after some of your key developments. So if you're disclosing those concepts to other parties that you're working with, if you want to publish that, if you want to use it in marketing materials, file on it, make sure that you establish this is ours, and then go on and do what you need to. But also, again, just taking a view of this, of wanting to establish an effective IP strategy early on and implementing it throughout the course of your company's lifetime, as well as updating it regularly, can be very key for the success of handling your IP successfully for a company. So that's all of my part of the presentation. Sorry, it went a bit long. So we can either open yours separately, or it had a, if you don't mind white bars at top, we could do that. Which one do you
that's
prefer?
okay. Yeah, we can just use, I can handle that. Thank you. Awesome. Hi everyone, my name is Matt Smith. I'm a co-founder at Embr Labs. I started this started as a project after finishing my Ph.D. at MIT, and I'm just going to talk a little bit about my journey commercializing a technology, and we've been working with Wolf Greenfield the whole time, so kind of just adding a little flesh to the bones of all the best practices that John just outlined. Is there a preferred amount of time that I take at this? This is my first enterprise event. All right, you heard it. All right, thank you. I'll work on my volume and speak as slowly as I feel like. No. So Embr Labs we think a lot about temperature, and uniquely, what's unique about us is an emphasis on how people experience temperature. So right now in this room, the room is one temperature, but we're actually all feeling it slightly differently. Some people might be uncomfortably cool. Others, perhaps those publicly speaking, might find it uncomfortably warm, and some people are perfectly comfortable. We started out this project with a thought experiment that led us to a really unique sequence of realizations, which I'm just sharing in terms of how we ended up viewing our technology and in a position to file a number of patents related to the technology that we develop. The thought experiment was about personal comfort in the built environment and the appreciation that just a little bit of personal comfort control, feeling a few degrees more warm or cool, could actually have a big impact on the built environment. So if you allowed the thermostat in buildings to vary by a few degrees, you could actually save 20 to 40% of the energy used by the HVAC systems in those buildings, depending on the climate that that building's located in. And similarly, people's productivity drops off after when you are just a few degrees uncomfortable. And if you plug that into spreadsheets, multiplied by the fact that we all spend 90% of our time indoors, we got big enough numbers that we thought this was a really interesting area to explore. This is different than most people thinking about wearable heating and cooling, because when presented with that topic, most people think about like soldiers in the desert or the North Pole or these extreme environments. And so for us, we were really coming into this thinking only about a few degrees of personal temperature control. This led us to ask ourselves, well, how do people feel temperature? Because it seems like intuitively a little bit of a thermal sensation could offset how you perceive the temperature of the room. So we learned a lot about thermoreceptors. In the interest of people's time, I won't bore you about this, but you feel temperature through temperature-sensitive nerve endings in your skin. You actually feel temperature different. Warm sensations use different nerve endings than cool sensations. They even have different properties, but both of them have this really unique behavior that they overfire in response to temperature change. So this is a temperature profile, and this is the firing rate of a cold thermoreceptor. When the temperature is changing, the firing rate is high, and that's a very strong thermal sensation. But over here, even though the temperature is as cold as it ever was, the firing rate has decayed. So from an engineering perspective, we thought that's pretty cool, and in terms of a sensation per unit energy, you'd use a lot less power if all you did was this and you never worried about that. And the first patent application that we filed, which was recently awarded, was about the design of thermal waveforms, as we call them. Our first product is called Embr Wave. So it is our technology and our first product use a thermoelectric cooler. So it's a conventional cooling technology. But we embedded some temperature sensors in it and developed control systems to deliver temperature profiles that explicitly harness this effect, with the thought that we could significantly reduce the power consumption of conventional thermal systems. And it worked. So thermoelectric heat pumps in typical applications are using tens of watts, and our wristband uses about 1 watt. So we were able to reduce the power consumption by about a factor of 10 from conventional systems. As a result, make it wearable, and on top of that, we layered a full IoT architecture, which I'll tell you more about. Embr Labs, though, and this is where it starts to get into the journey of a startup and figuring out your business models and what are you actually doing with the technology you're developing. We've always felt like we're going to launch a consumer product but not scale a consumer product, because that's really expensive and kind of a graveyard of wearable devices. So we're launching a consumer product. We're very committed to this as a part of our business, but we're simultaneously seeking co-development agreements with B2B partners. So in terms of IP, there's IP in terms of the product and the customer, but we also do a lot of IP agreements with partners with whom we're doing co-development projects. So both sides of it are very IP intensive. To date, this has been about a 6-year journey so far for me. I finished my Ph.D. in 2012, and this project started in 2013. We've raised about $4 million. The consumer product has been pretty successful. For a company that's only raised $4 million, in our first year of sales, we've done over $7 million in revenue, shipped over 30,000 units. We just had a Mother's Day sale and sold out, so will be being opened by, delivered to thousands of moms on Sunday for Mother's Day. We filed 6 invention disclosures and had our first US utility patent granted this past year. So things on the consumer side are going really well. We also have a co-development project with Johnson & Johnson right now that's public, and we're in the process of several others. One of the benefits of launching, yes?
How long from when you filed the application to when you actually get the patent issued?
Oh, I have a slide meant perfectly to like depress and overwhelm you about the process. So we'll get to that. Yeah, and then we can, no, I left the dollars off. That would have been too much for even me to present. So one of the tools, it's a balance of B2B and B2C. Some people, depending on your philosophy about entrepreneurship, that's not the best thing to do, but we've always felt like the B2C was going to serve the partnership activities, and that's been extremely helpful now that we have 30,000 data points, because we're starting to see that our device is being used for a range of applications, and we have consumer adoption to support it. So right now, we started off marketing this device for people who are chronically cold and chronically hot. We got a lot of customer feedback from women using it for hot flashes, as well as people using it for stress and sleeping. So this is both expanding our consumer market, but also helping to inform our partnership strategy. And we are coining this thermal wellness, people for whom a little personal temperature control can meaningfully help them feel better, help them with symptom management across a range of conditions. So this is, we had a conversation about it and opted not to at this time, but that did come up. Yeah. We'll put that on our next agenda. Right now we're using it, so as far as that gets us for the time being. This is one of my 2 IP-specific slides. So these are the nerdy slides that don't make it into our normal pitch deck. We started out developing a thermal system, and then I mentioned layered onto it an IoT technology architecture. So we think of our platform technology from bottom to top. We have the actual thermal sensation system, the control systems, the integration of those into wearable devices, that communication with the mobile app in the cloud, and then all the magical things that can occur in the cloud. Also, just for curiosity, we really like to think about how we can touch the user through every level of this IoT framework. So that's not particularly unique for IoT companies, but for maybe thermal system companies, it's unique to be thinking about your technology extending up into the cloud. I mentioned that we filed 6 invention disclosures that have turned into now patent applications. I tried to kind of capture where they were with these little file icons. These are approximations, but where our first patent was filed and where really what we believe was the foundation on which we were building this whole architecture is around control systems. So we now have 3 filed related to the control system. We have 1. These are similar in theme, and I just had to put them somewhere. We have 1 related to the architecture of our actual thermal actuators, 1 related to the sort of mechanical integration of our unique control system into wearable devices, and then a sort of mobile app and cloud related invention disclosure that we or patent application that we filed. So that's 6. We're starting the development of our 2nd generation technology. And with that, there's probably will be a handful more this year. But what's really hard to grasp until you're experiencing it is what is what does having 6 ideas that you want to protect actually mean for your business? And this is my first attempt at presenting this slide, but on the top is some milestones for our company. And on the bottom is some IP-related events with timelines. So just to kind of talk through my company's journey, we won a hackathon we entered a hackathon in the summer of 2013 and won in the fall of 2013. we had gotten some advice from someone at MIT. You should file a provisional patent application before presenting at the finals of this hackathon, which was very valuable to us. I don't know how many hackathons actually say, oh, by the way, if you come up with something really valuable, you should just withdraw from this hackathon immediately and not tell everyone what you just made. Thankfully, we filed that provisional before presenting. We basically spent another year on the competition circuit. We were part of an Intel Make It Wearable competition. That fall, there's a little dollar, these are financing events, so we got $150K out of that, which basically got us through the next year. We were still a very small operation. During this time, we were trying to figure out how to make our prototypes robust enough to get into the field. We actually had this problem where we could give you demos and things felt good. We could take our benchtop setup home and sit on the couch and play with it, and we were like, we're convinced that this is really cool. But when we wanted to, say, do a pilot with people in offices or women suffering from hot flashes, we'd send stuff into the field and it would break. We ultimately figured out the mechanical design that would allow us to package all of our components and make this robust enough to send into the field in the first half of 2015. And that allowed us to start doing extensive pilot trials. So then we got 50 prototypes made, did pilot trials all through 2015, and with that data was actually able to raise our first meaningful convertible financing round. So just moving through, one of the things you can notice is this. So this is the timeline that you asked about earlier. So the provisional from 2013 was granted in early 2019. Yeah, I think that's correct. Early this year or end of last year. So that's a pretty long time. And one of the things I'm trying to communicate here is the timeline between what we were trying to do as a company, even like a slow kind of digging in the trenches, getting data, raising money, commercializing our first product company, it still took us, we still got a product to market and sold tens of thousands of units before we got our first patent granted.
Was the delay purposeful? Because as I understand it, once you file a patent, the world knows the magic. So keep it, kind of delay it, keep it secret?
We, our delays were purposeful because of delaying IP expenses. So we would file a provisional, wait 11 months and 29 days, or no, wait almost the full year, file the PCT, which would get you another 12 or 18 months often before actually filing the US patent. So for us, it was really all about pushing these dots out into the future so that we could keep investing resources here into corporate development. John mentioned, just to finish the timeline, we had a Kickstarter in 2017, started shipping in early 2018, and then started delivering software updates through 2018 into 2019. And we just had our second Mother's Day sale. Along the way, we've filed our second patent related to prototyping. Here was when we were really getting into the actual product design. So we filed a design patent, we filed our trademark, we filed our third utility patent around the same time that we had our first national phase filing. So it's like, oh, you're a startup, what markets are you going to enter? We're like, obviously all of them. Like, what market are we not entering? We still down selected to Europe and Japan, but you'll notice that the second one was we then only went to US and Europe, and the third one we actually only filed in the US because we started realizing like we need to really, the multipliers of filing internationally are just killer. Like you could basically imagine every one of these dots is at least $10,000, but don't count them up and tell me what that is. And some of them are not, but Japan, you have to like translate everything, and then the office responds, and that needs to get translated, and then you need to respond, and that needs to get translated back. So, anyways, there's really been, the strategic use of resources, time and money, are like very valuable to startups, and the IP game is very long and expensive, and we've been learning as we go about how to align our strategy with our resources. We have always felt like we are a technology company with a consumer-facing product. So our mantra has been basically invest as much as we can in intellectual property while bringing this product to market. So we've actually, our internal R&D resources are, I think it's fair to say, comparable. What we've spent on internal R&D is comparable to what we've spent on IP, which is probably together summed equal to what it's cost to launch a consumer product. So just to give you an idea, this is a significant area of investment for us, because whether it's for the consumer product or for the partnerships, we needed to confidently say we have this protected. And not only do we have it protected, but we have it protected in a way that we can continue to innovate in each of these little squares, and the other ones will still apply in terms of delivering the full system. We continue to develop utility patent applications and file them, and as I guess I'm just thinking about other points to make on this. The main takeaways: money, time. National phase filing is very expensive, and one part of the story that I didn't mention is that this came out of a hackathon at MIT, but we were lucky enough to get in writing almost immediately from the technology licensing office a statement saying that we own our IP and that they didn't. So we're not licensing from MIT, we own all of our own IP. At times, we've wondered about, you know, how much of our IP costs would have been defrayed if MIT was leaning in on that, and that's not something I have firsthand experience on, but our partners like hearing that we own all of our own IP. We don't have to deal with any terms of licensing, and we think we have a clear path ahead for continuing to develop IP. So that is just a little bit about Embr Labs, and I'm happy to answer any questions that. Yeah, well, the reality of patents as a startup is complex. We don't have the resources to enforce any of our patents, to be fair. So for us, it's about putting the flags in the ground, writing really high quality provisional applications that will give us meaningful patent applications. And our mindset is the people that we're partnering with or the people looking at acquiring us will be able to say, oh, this is enforceable here. But at our current stage, actually chasing down people infringing on patents is still a little beyond the scope of our resources at this time. Well, we had a really, the short answer is no. When we launched our Kickstarter, we actually had a knockoff, like an imitator in Hong Kong, launch a knockoff Kickstarter that we were dealing with. Thankfully, they were a total scam, and so they never delivered anything. We would have had protection, but we are not seeing anything yet, thankfully. Great. John, do you want to come back up to address any additional questions people have? This is our 11-person team right now. That's my end slide. Thank you guys for.
Thank you.
Yeah.
So you've already invested in bling for the corporate uniform.
Oh yeah, yeah, yeah. The amount of resources that student-founded startups spend on logo designs, logo redesigns, T-shirts, URLs. They're relatively cheap compared to our IP expenses, so we don't feel bad about it.
Coming back to the question of hackathons and presents.
Mm-hmm.
What's your experience? Should you give up the right to patent something if you do one of those presentations and say, here's my startup and here's my great idea?
Well, I defer to John for the correct answer.
To what extent is that important or not important?
Well, again, public disclosures, if it's before disclosure in the US, you're given that 1-year grace period. So assuming that you just developed that technology at the hackathon and you disclosed it at the hackathon, you will have a year in the US to go after your application and to actually get a patent still for that. Now let's say that you're interested in foreign rights though. So you do that hackathon. You then are interested in going into Europe and you file that application, let's say a month after the hackathon. You're out of luck. You're not going to get any patents in Europe. And that's just the way that the game is played, unfortunately. And it's, so again, if, I think as Matt was saying, if you find out in that hackathon that you have a great idea and that it's going to be the next big item, maybe don't disclose it. Withdraw from the hackathon. Go after your technology elsewhere, at least before you disclose it to people. Somehow get some sort of application on file that will actually cement those rights, both here in the U.S. as well as internationally.
So 20 years if you need after you file for a promotional patent or after you file for PCT or after you file for the US.
It's whatever your first non-provisional is. So if you file that provisional application, you're given a year and you have that priority date. But your 20-year term is from the first utility application you file, whether it's a PCT application, whether it's a US application, it's whatever that first true patent application is. That's what the 20-year term goes from.
So when do you get the patent? Your application, when do you get patent? After PCT or?
So it's 18 months from your priority date. So if you claim priority to a provisional application, it'll be 6 months after you file that conversion at the 1-year mark. If it's you file just an original US application, an original PCT application, you're given 18 months from that filing, and that's governed by international treaty.
Trying to recall you suggested avoid provisional, but
I didn't say
provisional.
all of it. I didn't say to avoid provisionals. I said to avoid low quality provisionals. I actually, especially for startup companies, the strategic use of provisionals and PCT applications, just as Matt said, you can delay those costs. You have that year mark to file the PCT application. You then file that PCT application. You then have 18 more months before you have to decide to go into Europe, before you have to decide to go into the US. So it's helping to extend that glide path for your patent costs. It's just that when you file that provisional, don't file a cheap cover sheet. That's a false security blanket. It will burn you every single time. And again, it's the cost that person I was telling you about, where they could have filed the application correctly the first time, the amount of money they have put into the appeal process to argue literally over a textbook definition that I learned in my freshman year thermal transfer class, it boggles my mind that we're having to spend that money. And it's so critical to his company to get this early application that he has to. The company, I won't say that the company is writing on it, but it's going to be very economically advantageous to them if they can get that protection, because they can pretty much shut out everybody else from doing what they view as like the most critical aspect of their system.
Two quick questions. One for trade secrets. Are there actual legal protections associated with that, or is it just like
There are legal protections. If you have misappropriation of trade secrets, you can't sue people based on it.
so
Again,
former
it's
employees, supposedly?
say that again.
That'd be for contractors, former employees, things
It,
like that.
it can be pretty much anyone and everyone that is privy to trade secrets and had a duty to keep it as a trade secret. So if it's that contractor that you worked with and you disclosed your brand new compound to them and you were keeping that as a trade secret and you weren't disclosing it to anybody yet because it was not ready, and they go out and they tell the world about it, you can sue them on that breach of contract. And that's in addition to misappropriation of the trade secrets. It could also be corporate espionage. It could be any number of things. It's going to be very, very fact specific.
Oh, yeah. So in instances like that, how would you prove corporate espionage versus reverse engineering versus?
Well, if it's just reverse engineering where somebody has, let's say that they bought your product and they reverse engineered it, typically unless there's some contract that they're breaking on not reverse engineering it, there's nothing to prevent them from doing that. In fact, that's one of the things that cuts against something being a trade secret. If I sell my product to you and you say, okay, thank you, I'm going to rip this apart and now I'm going to knock you off, they're allowed to do that, quite frankly, and that's where patents come into play. So if they can figure out what you're doing based on the product you sell, that's where you should be filing a patent instead of a trade secret. Now that's in contrast to say a manufacturing process or a process for like one of my favorites that I've worked with is an electrodeposition process where there is no way anyone will ever know the specific bath, the specific temperature, the specific all of the various parameters you could play with. There are literally millions upon millions of combinations they could have, and they found the exact one that works. So they're never going to be able to figure out how to deposit that material in the same way. So instead of patenting that specific process, they've kept that entire deposition process secret, and they're going to keep it secret for the rest of the lifetime of the company if they're able to. So.
But it's such, the legal protections are such that if someone, say corporate espionage were to occur, they could still claim, no, we just reverse engineered what you did, and
well, it's going to be dependent on what facts you have and whether or not you can actually prove that. But it's again, it's very, very fact specific. But if you have a trade secret and someone misappropriates it, you can sue them based on those grounds.
So
Yes.
a piece of software that's been sold commercially,
Mm-hmm.
that's not patentable.
You can patent software, and like again,
But
it's going to be
already been in the marketplace.
okay. So it's already been in the marketplace. Let's say for
And my understanding is software is not sold, it's licensed. A contract is, you have the right to use this, you may not.
so you're saying I've bought a piece of software that is licensed to me for personal use, and you're
For
saying
corporate use.
okay, corporate use, whatever, some use, and so your question is, can I patent that software that has been licensed to me? What
Well, my question, but if it's already been in the marketplace.
yeah, if it's already been in the marketplace, it's been sold, it's been used, it's out there, it's not new. It's sort of like one of the hallmarks of patents is whatever I want to patent, one, I need to have actually made it. If somebody else made it, I can't patent it. And two, if it's not new, it's been in the marketplace, it's been sold, it's been used, I can't patent it because it's not new either. So
trade secrets is the protection.
well, those people licensing the software to you, they could be doing any number of combination of those different protections we've talked about. They could actually have patents to the software that they have. And so if you try to knock them off on the functionality, maybe there's a specific, let's make it a little bit more concrete. Let's say that it's an imaging software and it's using a very specific algorithm to get rid of motion blur within a video stream that you're shooting. And they figure out, oh, based on what's happening from this original frame versus what's output, I know they're using this algorithm in this way to do this. And I may not have the exact code because maybe when I decompiled it, it didn't quite give me everything because it's more of an art rather than a science decompiling someone's pre-existing code. But they can come out with the functionality. And they say, you know what, I'm just going to have somebody write it up. I'm going to have them implement those same concepts. Oh, but gee, that person I licensed it from and that I've reversed engineered it from, they patented that process of handling images. And so they can stop them that way. But there's nothing to stop me from taking somebody's software and playing with it. People do it all the time. It's just, and that's why you have layers of protection.
Obfuscation, protection by obfuscation.
All of the above. Obfuscation, patenting, trade secrets, whatever works for whatever you're dealing with. Yes?
Apologies if I missed this, but do you have to actually apply for a copyright, or like when you copyright the bottom of your
The second my daughter makes a drawing at after-school care, it is a copyrighted material.
And so if I get, say, like an investor debt from a company like yours, and we have to sign an NDA or a Confidentiality, theoretically this debt is copyrighted material of Embr Labs. If I were to send it to someone because I wasn't under Confidentiality, could I still run afoul of copyright?
Well, technically, it would be their copyright material, though I think that there might be some issues with the fact that we're presenting at the Enterprise Forum on that. But also you need to think about realistically. There are such caveats as, and I didn't get into this just because I didn't think it was relevant for a startup type of application discussion here, but there are such things as fair use. There are such things as sort of like, is he ever actually going to come after you for sending your presentation to somebody? Now, if you modify that, stick your face on the front of it and call it your company and then start putting on a Kickstarter, well, you might be talking about something different at that point. But if you're just forwarding something along to somebody, making comments on something, you don't need to worry.
So can you please tell me more about why did you file a PCT file instead of US? Because if you cost it over the same in then if you file a US first, you can hold it. But if you file a PCT, it doesn't matter. I mean, you have to file for other countries at the same time. What is the real advantage of file a PCT earlier? Instead of a
Timing,
US?
cost, and when you need protection. It's a pull between each of those. If you want protection now and you want it fast and you don't care about cost, file everywhere on day one. If you want to delay costs and you don't care about how quickly you get your protection, file that provisional, go to that 1 year date, file your PCT for your international, go 18 months out from there, file in the various countries. And it's just a question of when do you want protection and how long do you want to delay costs.
So PCT cheaper than the US application?
No, PCT is actually more expensive than US. So if you're only ever interested in US, just file in the US. If you think you might be interested in international 30 months from now, go for the PCT. At least then, for just a little bit more money, you save your rights to possibly go international later on.
Two very quick questions. Well, one is a provisional held confidentially by the patent office?
Yes.
And the second question is, I'm just trying to get my head around, is the idea patentable or the implementation of the idea? In other words, I want to create a device that projects computer screens onto a wall. Is it that idea that's patentable or that implementation of the idea?
It's going to be very, very fact specific. At the most general level, ideas are not patentable. So if it was, say, something I can do inside my head, a mathematical process, for example, I can't patent that. If it's something that is present in nature, I can't do something that's present in nature, like compounds or biological molecules in your body, I cannot patent that. Or the idea of, gee, I would like to extract those molecules from your body because they're very cool, but I don't have a way of doing it. This can go down a little bit of a rabbit hole.
But for example, the idea of cooling the wrist cools the body, or gives the perception of cooling the body.
Mm-hmm.
Is it that idea that was patentable, or the fact of implementing it that was patentable?
So this is where we also start talking about what's been done in the prior art, because everything that you do has to be new, right? So the idea of cooling people, even locally for massage, for stimulation, for therapies, that's been known for millennia. But the very specific concept of we're going to cool it with not only are we going to cool people, we're going to use this specific temperature profile with this specific increase in temperature rate versus this amount of time versus any number of other parameters. That's where you start talking about something new, and it is getting more towards the implementation side. But the very broad idea of I'm going to cool somebody, one, that's been done, and two, that's too abstract.
Thank you.
Yes?
In the pharmaceutical, the people say composition of matter patent is much, better or stronger than the use patent. The reality is composition of matter patent. When you discover the molecule, file, so by the time it comes to the market, maybe 12 years has passed already. And the use patent, often you come up with a completely new indication for existing drug. And if you have 20 years, firsthand, why people sort of plan upon a use patent?
Well,
People say it's not impossible, but
composition is stronger in terms of it's easier to use. It's easier to find out someone's infringing. It's easier to prove they're infringing. It's easier to enforce it. That's why people say the actual physical products, those are what people prefer to get patents to. Now, you're right. When you first get that composition application, it's going to go 20 years from now. And as you've come up with those additional uses, those additional, maybe a new compounding process, a new...
For the pharmaceutical, the problem is you patent the composition, but to clear all FDA, it would be easily 10 years.
Oh, easily, yes. And there are, this can go down a different pathway where they sometimes will give you additional time that you can tack onto the end
During
of your
the
patent
review time.
because of the review, the delay from the review. They will give you what's called patent term adjustment based on the federal review process. But again, going back to your original question, which was sort of why are the process patents frowned on? I just think that they're different ways of cover. It's different timings, different ways of covering your process, and it's going to come up at different times. So you come up with the original composition, that's what you patent. You come up with the new use, that's what you patent. And they are going to have different time frames in terms of when they actually expire, but that's going to really depend on when do you want to enforce stuff, how do you enforce it, and it's just creating that fence around your overall product, and it's going to be an evolving process over time.
So taking that example, the pharmaceutical industry, if there is a claim of infringement on a constitutional patent, how would they go about proving that? If the basis is, you know, a protein material, or can't sequence a protein, et cetera, do they do functional assays, or what's the basis for?
It's going to be very dependent on what material you're talking about. If it's let's say, instead of being a protein, it's maybe a particular crystal structure of the electrochemical material, you can figure out what the composition is with, say, XPS. You could then figure out what's the crystal structure with this. And so there are tests and indications that you can figure out to do this. I mean, just for example, they originally figured out what protein sequence they were using. You'd probably have to do similar types of tests to figure out this is the way that we figured it out for our protein originally. This is the way we figure it out for your protein, and it looks like it's the exact same. So based on that, we're going to take you to court based on sufficient evidence to allege that you're infringing our patent.
Along those lines, kind of an extension. Can you talk a little bit, or maybe give an example of the sort of process you might work the patent? Because it is difficult to tell someone's infringing.
So when you're saying the process to patent, you're saying considerations or the actual, like, what do you do when you write an application and work with patent like this?
If you patent, put in a patent for like a manufacturing process, how would you, in what instances would you actually put it in a patent? Just because it's difficult to tell if someone's used that manufacturing process.
Okay, so you're saying, would I write an application for something that's hard to detect? Is that what you're asking, or
rather, what? Yeah. So what are instances you have a method for producing something?
Yes.
Is there any sort of benefit to actually working on that, or is it strictly intrinsic?
It really depends on whether or not you can determine if someone is using that process. So if there is no way that you will ever determine that someone is infringing your process, and it's something that people will just keep in-house and you'll never find out, that may not be that valuable to patent, because you can't actually enforce it against anybody. And that would cut towards keeping a trade secret, not filing a patent. If that process leaves telltale indications that I see that it has this crystal structure with this size grain and with this leftover residue on in the composition, that means that it was deposited with this particular process, that it's leaving indications that you can figure out, then maybe that is something that you patent. And you say, based on all of these indications, the only way you could have made this was with our process. That's something you would go with. Versus maybe it's something that's very public. Maybe it's something that it's a particular process that's not in their manufacturing facility. Maybe it's a process that's implemented, maybe it's in an autonomous vehicle on the road. You can see the way that the vehicles are interacting with each other. You can actually get that vehicle. You can test it. You can play with it. You can disassemble it or reverse engineer it. And you can see how those processes are implemented. But that's, again, it's going to be very fact specific.
There's no legal recourse for, say, subcommitting them and looking at their corporate records to see if they...
Say that again?
Is there any sort of legal recourse for if, let's say, you wanted to subpoena someone
Discovery.
that process? Yeah.
Okay, you're talking to... Yes, you need to have... This is getting into how do you set up a litigation against somebody. You need to have sufficient evidence beforehand to... Basically, you need to have a good idea that they are infringing. You can't just go around fishing for people. But usually, you'll do that with any number of things. You could have private investigators. You could reverse engineers. It's going to be so fact specific, it's almost hard to talk about. But it's once you have that initial reason to have an allegation, they can get into discovery, and that's where you can ask for pretty much everything, including the kitchen sink, for them to tell you about it. So.
Excuse me, Matt, when you did, as you've gone through the last few years, what and you look out, see us saying, well, maybe we want to do this. What advice would you give for wanting to do that differently or not done?
I think that first-time entrepreneurs are often put in a position to climb to the highest mountain that they can and yell as loud as they can about what they're doing, as kind of a form of public acceptance as validation or something for what their idea. I think now that I've been at this for a while, I see experienced entrepreneurs like staying in stealth mode until they've raised $5 million. And I think that's a challenge for our company exists because when we won that hackathon, we got a write-up in Wired and overnight had 2,000 email addresses of people who read about what we were doing. So like we only existed because...
Did you go out and buy up every, who's that jungle guy?
Well, well, if you had visited our website anytime in the last few months, every website you went to in the last few weeks would have had our ads on it. But so in terms of for people doing this for the first time, I think the seeking validation through public approval, like on the competition circuit, it's possible to do that without disclosing a lot about your technology. And I think people in the kind of entrepreneurial academic ecosystem are surrounded by cheerleaders who are it's just 100% supportive, and you don't realize that you don't actually have to answer every investor's question about what you're working on. And that's something that, that's a melody that I don't think is sung nearly as loudly as entrepreneurship is great, go out there, tell the world, and go for it, which has, IP implications. Thanks for the thoughtful question.
Thank you for your time.
I was intrigued that this, infringement. I mean, if you didn't have resources to go after, potential infringement. But now I think about it, most startups don't even have. So is that a right? Don't worry about infringement.
I think I had it explained to me by a startup, a co-founder peer of you're building out your little stack of patents and someone else has their stack of patents. And if you ever disagree, as John said, chances are you're gonna just wanna trade some ability to both continue operating. The scenario of you have one piece of paper and they have 0, and now you're going to destroy them, is certainly, even if that was the case, yeah, we wouldn't have had the resources to, we would not have chosen to allocate our resources to doing that unless there was some context that there was immediate short-term upside to that.
I think Matt's absolutely right there, where you need to look at the scale of whatever economics you're operating at. If you're talking about something that's maybe there's $1 million of revenue split between both companies that are angry at each other, unless it is a vendetta, you will never litigate that, just because the economics aren't there. By the time you go through the entire litigation process, both companies have spent more than they will ever get back. Now, when you start talking $4 million, $5 million, $10 million, $20 million in terms of potential revenue that you're dealing with, you're talking about a large enough threat to your company, a large enough market share that, probably it is worth litigating. Whereas if you think that you have the stronger position and that you can't come to some sort of more negotiated settlement that's amicable to both parties, then that's the option that's left. And the economics at that point point towards litigation. But it needs to be a well thought out process, not only in terms of the strategic side from can we enforce this, it needs to be looked at from the business side of should we enforce it.
Thanks for the question. All right, great. Thank you, guys. Whew.